Hello everyone, this is a presentation by Zhaoxun. My student number is P111446 and my topic is Medical Malpractice Liability Determination. Medical conduct based on patient's right to informed consent. Along with the depending of the concept of human rights and the continuous advancement of medical technology, the patient's right to informed consent has slowly evolved from a medical practice to a rule of medical ethics that is gradually receiving widespread attention in various countries around the world. Patients have evolved from a high level of trust in their doctors to a desire to be fully and thoroughly informed about their illness, treatments, opinions, medical measurements, outcomes, and risks, and to make choices of their own volition based on these. The legal protection of patients' right to information has therefore become more demanding. In many countries, the patient's right to be informed and the scope of their right are clearly defined in law or in declarations, and the duty of medical institutions to inform is clearly defined. In China, some laws and regulations, such as the regulations on the handling of medical accidents and the law on medical practitioners, have relevant legal provisions on the patient's right to information, but the content of the provisions is not detailed and complete, and there are contradictions in legal practice such as legal conflicts. Based on this article uses qualitative research method to conduct a comparative analysis of the laws on the patient's right to information in common law countries and civil law countries. In addition, the liability of medical institutions is discussed in relation to the relevant legal content of medical law and tort law. The aim of this paper is to provide a reference for the construction of the protection of patients' right to information under the Chinese socialist legal system. As far as the findings of the study are concerned, it is recommended that the legislative system be improved. On the other hand, a special law such as the medical law can be enacted under the civil law systems to improve the legal system for the protection of patients' right to information. On the other hand, the legal rights enjoyed by patients and the specific content of such rights can be clarified by combining the advanced practice of other countries and the relevant provisions on the tort liability in China. In summary, this study analyzes the patient's right to informed consent from a comparative law perspective and provides some reference for the construction of the legal protection of the patient's right to informed consent in China. In addition to introduction and conclusion, the essay will focus on the following sections. In the first part, the patient's right to informed consent is described in general terms. It mainly discusses the concept and content of the patient's right to informed consent, analyze the origin, formation, and development of the patient's right to information, and examines the nature of the patient's right to information. In the second part, the current similarities and differences in the protection of the patient's right to information in common law and civil law countries are first analyzed using a comparative approach. Secondly, it examines how patients can use their rights to information from a legal perspective. There are two ways in which patients can use their rights to information. The first is where the patient takes initiative to ask the doctor one, and the second is whether the healthcare provider is obligated to take the to inform the patients of the condition. This will be discussed in the section. In the third part, legal issues such as the ways in which patients can exercise their rights to information and the liability of healthy care providers are examined. How patients exercise their right to informed consent in the field of medical law and the field of tort liability law, and what are the circumstances in which the right is violated. Whether the legal protection when such situation occur is timely and appropriate is one of the main focuses of the discussion in this chapter. In addition, this paper will also discuss medical practices that appear to violate the patient's right to information but do not legally constitute a violation. For example, whether the patient's right to informed consent may be limited by law in the context of compulsory drug treatment, physiatric patient and medical conditions in which sudden onset infectious disease such as COVID-19. In the first part, the current legal issues in the use of informed consent by patients are explored and appropriate recommendations are made. For example, the law should clarify a standard and the scope of what healthy care providers should inform. In addition, how to improve the legal protection of compulsory medical practices. Further, how patients should be protected when they refuse to receive treatment. Finally, the paper will conclude with a summary statement reviewing the important elements of the patient's right to informed consent, the obligations of healthy care providers, the current legal issues in China, and the relevant recommendations to address the above legal issues. In jurisprudential analysis on the overview of patients' right to informed consent, the right to know refers to the freedom of the subject to know all kinds of information about his or her rights in accordance with the law. Ken Cooper was the first to introduce the citizens' rights to know in 1945. The right to consent is a right of citizens to express their agreement or disagreement with the option of another person. Victim consent has its origins in the Old Latin legal proverb "Volenti non fit injuria." According to Urbian, the act that is done at the will of the victim is not wrongful. Since then, the principle has evolved into the rule that an act promised is not unlawful. This rule has since been adopted in civil law and common law. In legal circles, the patient's right to informed consent is generally considered to have its origins in the doctrine of victim consent, which was the first document in the English case of Slater in 1767. In the United States, patient consent cases have focused on the lack of patient consent in relation to the medical treatment, such as the Pratt in 1905 and Slaughter, both arising from a lack of patient consent. The earliest case of informed consent by a patient in English law was the Slater case in 1767. The English law of informed consent was later established in Sidaway Sues Beslander. The United States is generally considered to be the first country to refine the doctrine of patient-informed consent. There were three broad periods of time. The simple consent stage in Slater, Sue Baker, and Stapleton in 1767, the judges held that it was just to hold medical practitioners responsible for failing to achieve standard medical care when exercising medical care without the patient's consent, the voluntary consent stage. In the 1940 case of Zhaoxun, New York Hospital, Justice Cardozo held that every person of full age and sound mind has the right to decide for himself whether or not to take medical action in relation to his own body. The right to informed consent stage. In Germany, the earliest case concerning the obtaining of patient consent for medical acts was in 1887. Since then, the doctrine of informed consent has been upheld by the 1945 jurisprudence of German Federal Court of Justice to electrical stimulation therapy and by the jurisprudence adopted by the German Federal Constitutional Court in 1979. In Japan, the earliest case that went to the doctrine of informed consent was a 1971 decision by the Tokyo Court of Justice in a breast cancer excision case. In the above case, the patient had committed to the removal of her right breast, but the doctor, after studying a pathological section of the patient's breast, discovered that the cancer was also present in the patient's left breast. As a result, without the patient's consent, the doctor performed an operation to remove the patient's left breast as well. The court held that the operation was important to the patient as that it was necessary for the doctor to explain the symptoms and the need for the operation and to obtain the patient's consent again. The doctor was liable for the acts performed without the patient's consent. The judgments in the case affirmed that the medical practitioner's duty to explain and to obtain the patient's consent was a legal requirement. Compared to the development of the right to informed consent for patients in other countries, China has had a relatively short period of legislation. The first time the concept related to the protection of patients' right to informed consent was introduced in the law was in the 1982 when the Chinese Ministry of Health promulgated the hospital work system. In this regulation, it was stated that a patient's family or unit must sign the consent before a medical institution can perform surgery. It is that clear that China's regulation on the patient's right to informed consent are gradually being improved and the importance attached to it is gradually increasing. The United States has developed a strict system whereby doctors must inform their patients without reservation, including all aspects of treatment, which should be explained to them. By doing so, patients have a very detailed understanding of their condition and will not disagree, avoiding unnecessary disputes. In addition, the U.S. law provides for 4 necessary conditions, namely knowledge, information, understanding, and consent, making the relationship between the doctor and the patient more harmonious. In addition to these, the U.S. uses both legislation and mediation and legal tools to resolve disputes over patients' informed consent. In addition, the relevant insurance company will monitor the implementation of the medical treatment to ensure the patient's legal rights. Patients have a wide range of legal options to resolve their problems rather than seeking to disrupt the legal order. In 1990, the Patient Self-Determination Act was enacted in the United States, setting out the right of patients. In 1993, saw the passage of the Consent to Healthy Care Decisions Act, which states that very fully competent person has a right to self-determination, even if they make the choice to die. The Act also stipulates that the decision of the healthcare institutions must be in accordance with the principle of the best interest of the patients, and the patient's own true expressions to his or her wishes should be taken into account in the first place, or if this condition cannot be met, his or her wishes must be determined in accordance with the patient's forgotten values. Finally, the U.S. has regulated physician behavior through the development of a professional code of practice. In 1999, saw the American Board of Internal Medicine ratifying the 9 professionalism of physicians, and in 200 several U.S. internal medicine organizations and the European Federation of Physicians published medical professionalism in the new millennium, the Physician Charter. Physician Charter, which embraced the fundamental principle of the primary of the patient's interest, patient's autonomy, and social justice. In Japan, medical evaluation bodies has been set up from the central government to the local government, and the system of rating hospital and doctors from all walks of life has been developed. Patients and families can choose their hospital and the doctors through the rating system, which has motivational effect. In addition, the Ministry of Health, Labor and Welfare has created a corresponding database of the medical incidents and the medical incident symposium consisting of members of the community. The main object of the seminar is to summarize past experience in dealing with medical incidents so that the public can analyze the experience of the incidents, learn from them, and prevent them in the areas where they are more likely to occur, thus reducing the incidence of the incidents. The incidence of the doctor-patient dispute is also reduced by the reduction of medical incidents. Finally, under the supervision of the government, most hospitals have accident insurance for doctors in accordance with the regulation. The insurance companies are able to handle most small and medium-sized disputes, which also prevents doctor-patient disputes from rising. The Black's Law Dictionary states that a doctor must first give a detailed explanation of the risks associated with the medical treatment proposed to the patient, as well as other measures that can be considered, and must obtain the patient's consent on this basis when carrying out a medical procedure on the patient. However, when the patient has a treatment impairment of judgment, or if the patient is mentally ill or a minor, whether he or she can successfully exercise his or her rights will depend on an analysis of the law relating to the medical tort. Whether a doctor is required to respect a patient's decision if the patient experiences a brief period of unprepared judgment. In the U.S. case of Miller Sue Rhodesia Island Hospital, it was clear that the court did not take for granted that excessive alcohol consumption would render the patient incapable of the consenting, but the patient's capacity to consent at the time should be judged in the light of the circumstances and the patient's physical condition, and that the doctor should respect the patient's own wishes. Prior medical directives in 1990s, the Patient Self-Determination Act was passed in the United States, specifying that advanced medical directives should be respected. In most cases, mentally ill persons have difficulties in understanding information, so the law does not generally support self-determination by mentally ill persons, but rather the consent of their guardians on their behalf. However, as long as a mentally ill person can accurately understand the content, meaning, and consequences of the content, then their consent should also be respected. Some countries in continental Europe explicitly limit the age at which minors can give consent. The Dutch Civil Code provides for the right of co-determination for children who has reached the age of 12. For example, the consent of the patient cannot completely replace the consent of the child. Section 3 of the Austrian Medical Institutions Act sets the age of valid consent of children as 18 years of age. Countries such as the United Kingdom and the United States do not have the statutory law governing the consent of minors, but rather a body of jurisprudence that determines whether minors have the capacity of consent based on whether they have the capacity to recognize it. In addition, in the UK, minors under the age of 16 can make their own decisions in some circumstances. The Department of Health and Social Security (DHSS) states that doctors can advise a child under 16 years of age for contraception without the consent of the girl's parents. Consent is not required for minors' invasions. When a patient seeks treatment in hospital, it is already foreseeable that minor medical acts will cause slight damage to the body, which is an unavoidable situation in the course of the medical diagnosis and does not require the patient's consent. The Dutch Civil Code states that consent is deemed to have been given if the medical measures involved make some insignificant measure. This was also established by the decision of the German Federal Supreme Court in 1980. The patient's consent is presumed in cases of emergency. In a critical situation, the patient is incapable of giving consent and cannot contact anyone else who can act on his behalf. The doctor's action to save the patient's life is an act in the patient's interest and not against the patient's own will, so the patient's consent to medical treatment is presumed. Forced treatment, also known as involuntary treatment, it is a treatment that imposed by law and does not require consent. The ACA states that the treatment must be compelled when the refusal of treatment would threaten the public. The controversy over whether a patient's refusal of treatment constitutes an abuse of the right to informed consent has focused on two main aspects in legal studies. Firstly, whether a patient's decision to refuse treatment is valid when the refusal may or must result in the loss of patient's own life. Secondly, the validity of patient's decision of refuse treatment when the pregnant woman's refusal could affect the fetus. The agent must exercise the right to consent through the agency system. The agent exercises achieve the best interest of the patient if there is insufficient evidence that the agent's refusal or treatment was desired by the patient. Then the agent's actions will be found to be unlawful, for example, an abuse of agency. The reasonable doctor standard is a self-judgment by the doctor as to what he or she should tell the patient in a similar situation, whether the patient is ill from the point of view of the healthcare provider. However, it is problematic in that it relies too heavily on the ethics of the doctor, and the standards is entirely from the perspective of the provider, with the patient being the passive recipients of the information. The reasonable patient standard, the standard holds that whether a doctor fulfills his or her duty to inform should be measured by content of the information required for a patient with the capacity to consent to medical treatment in the same of similar circumstances to make a rational judgment. It is more greater towards protecting the rights of the patient. The specific patient standard. This first appeared in the U.S. court case. The standard holds that doctors should be required to analyze the medical information that needs to be explained in the context of each patient's different circumstances before doing so. Double standard. This is an idea put forward by the Japanese scholar Shinmyo. He believes that the reasonable doctor standards and the reasonable patient standard focus on one side of the doctor-patient relationship, while the specific patient standard exerts too much pressure on the doctor. The law should therefore be based on the standard of how much the average doctor should know about the patient's inner wishes under objective conditions. For example, the information that the patient probably needs to know, which is just right for the patient to be able to make a decision. When performing a medical act on a patient, the doctor should inform that patient of the nature, procedure, side effects, benefits, and surprises of the medical act and seek the patient's consent. In legal studies, there is a new view that doctors should state their patient experience and qualifications before treatment, which also been widely discussed. The interest involved the notification and of interest include inter alia, relevant research interest, commercial value, and direct rebates. In the case of D.A.B. Silbram, the notification of medical rebates was involved. The court in the case held that disputes concerning medical rebates should be governed by the duty of good faith and statutory law as a course of action, but by the medical law being the duty to inform. Circumstances in which notification is not required. First, in emergencies, a doctor is relieved of the duty to inform in an emergency situation. Second, accident infringement during treatment. This generally occurs when a doctor changes the surgical plan or expands the scope of a procedure during the course of surgery. Third, truthfulness would constitute a danger. A doctor may be relieved of the duty to explain if truthfulness would adversely affect the patient. In the Chinese legal system, the provisions relating to liability for medical informed consent are set out in the tort liability section of the Civil Code of the People's Republic of China. In the Chinese tort liability system, if a medical tort is constituted, the following conditions must be satisfied at the same time. Firstly, the medical institution has failed to fulfill the duty to inform. Secondly, medical damage caused to the patient as a result of the medical institution's failure to fulfill its duty to inform. Furthermore, there is a link between the failure of medical institution to fulfill its duty to inform and the result of causing medical damage. Finally, the doctor was at fault. Fault is cause and foundation of liability for medical damages. Article 1218 of the Civil Code of the People's Republic of China stipulates that if a patient suffers damage in the course of medical treatment activities and the medical institution or medical personnel are at fault, the medical institution shall be liable for compensation. Circumstance mitigation or exemption tort liability. The patient needs to undergo compulsory treatment where the public interest of society conflicts with the individual interest of the patient. The law provides for the right of a doctor to impose compulsory treatment without the notice and without the consent of the patients. This includes the situation discussed above. The first is the case of emergency treatment. The second is the act of compulsory medical treatment to prevent infectious disease such as COVID-19. The third is the act of compulsory medical treatment for certain groups of people who may endanger society or others with particular illness, such as the severely mentally ill. China is a codified country and has a large number of written laws. In China's healthcare legal system, there are legislative provisions on the duty to inform medical institutions and the patient's right to informed consent, ranging from laws, government departmental regulations, and the local government and administrative regulations. However, these provisions are scattered across different levels of law and regulations, and the coincident focus of protection has led to various legal conflicts. In addition, the conflict of laws is very serious. Improve the patient-informed consent protection system in legislation. Based on the current state of legislation on the right to informed consent for medical treatment in China, it is particularly important to establish an unfettered law that specifically mediates the doctor-patient relationship and protects the legal rights of patients. Drawing on the relevant provisions in common law and civil justice, the patient's right to informed consent can be improved in two ways. The first is improve the existing law on the right of informed consent in China. The second, by enhancing an entirely new medical law. In view of the current situation that China has many medical laws which are fragmented and conflicting, it seems more appropriate to formulate an entire new law, which is also conducive to the protection of patients' legal rights. In addition, the basic principles of China's medical law can be formulated by drawing on the regulations on informed consent of patients in other countries. The patient's right to informed consent can be tracked back as far as latter case in England in 1867 and has undergone a series of developments since then. Different legal systems have developed and explored the protection of patients' right to informed consent in their own ways. In terms of patients' rights, in addition to general provisions, there are provisions for intoxication, prior medical directives, mental patients, minor extent infringements, emergency situations, and compulsory medical treatment. With regard to the duty to inform medical institutions, the different legal systems also discuss in details the criteria for non-notifications, the content of notifications, and the circumstances in which notification is not required. In terms of tort liability, China follows the principle in 4 elements, namely the existence of a breach of law, the causing of a breach of result, the existence of link between the act and the result, and the existence of fault on the part of the doctor. In terms of liability, medical institutions are liable in tort for personal and property damage, but the standards of liability vary from country to country. There are currently many legal provisions on patient-informed consent in China which do not form an unified legal system, and there are various conflicts between different laws. This paper proposed the enactment of the medical law, which uses high-level laws to integrate other medical laws and achieve the purpose to unifying the medical legal system. That's all I want to talk about in my research paper. Thanks.